Hey everyone, welcome back to Canada, the Illusion of Freedom and System of Control. This is part 2, Canada, a Country Without a Constitution. I can well imagine what a lot of you must be thinking out there. That's ridiculous. That's nonsense. That's a conspiracy theory. Of course Canada has a constitution. We've had a constitution since Confederation in 1867 under the British North America Act 1867, which is now known as the Constitution Act 1867, including all the amendments, revisions, all the way up to the Constitution Act 1982 and the Charter of Rights and Freedoms. Of course, we have a constitution. You can go read it for yourself. The British North America Act was a statute created by British Parliament. It was given royal assent by the British monarchy, Queen Victoria at the time, to appoint, empower, a Governor General to unite 4 British colonies into one united British colony, to form both a central and provincial legislatures to assist him in ruling over the newly united British colony named the Dominion of Canada on behalf of the monarchy, Queen Victoria. That's all it was. The Bna was never a constitution. The Bna was never ratified by the people of Canada as a constitution. The Bna was never a treaty or agreement amongst sovereign nations to unite and form a federation. All the Bna was letters patent issued to the Governor General appointed by the Queen of England to establish a united colony under both provincial and central legislatures to assist him in ruling over the newly formed united colony called the Dominion of Canada. That's all it was. Since 1867, the Canadian government has claimed and maintained that the British North America Act 1867 was the Confederation of Canada, the ratification of a constitution, and the creation of a new nation. In fact, in 2017, we celebrated 150 years of Confederation. Big celebration. The Canadian government, both federal and provincial, also claim and maintain that they derive their power, authority, power, and consent to rule over the land of Canada, the resources of Canada, and the people of Canada through the British North America Act and its amendments and revisions all the way up to 1982. It's very important to recognize that's where they claim they get their power from. There are a lot of anomalies regarding the British North America Act from the time it was read in the Parliament of the UK to the time it got to Canada. For example, one anomaly is the Preamble. The Preamble that was read and approved by the Parliament of the UK is not the Preamble on the copy that arrived to Canada. It's a different Preamble. Secondly, the Enacting clause of the British North America Act was repealed in 1893 by the Statute Law Revision Act of the UK. Not only that, Section 2 was also repealed. Section 2 pertains to the Queen and the extension of her power and authority to her successors and heirs. That was also repealed in 1893 by the Statute Law Revisions Act. So there's anomalies regarding our Canadian foundational documents. And on December 11th, 1931, after the passing of the Statute of Westminster, everything changed for Canada. The status of the people of Canada changed. The status of the provinces in Canada also changed. For the people in Canada went from British subjects to sovereign people on sovereign land. The provinces went from united British colonies to sovereign nations. Just like that. December 11th, 1931. We were given full and absolute autonomy from Great Britain. Their power, their laws, everything. 100% full autonomy. You're free. Go create your own country. That happened December 11th, 1931, through the Statute of Westminster. The problem is, our Prime Minister Bennett, and the premiers at the time didn't want to give up their power. They didn't want to give up their control. They didn't want to give up their money. So rather than do the right and honorable thing and properly inform and educate the people of Canada on the new opportunities and the new challenges that our new status has presented us, the new opportunity to create a country by Canadians for Canadians, the opportunity to create both provincial and a federal, if we so choose, constitution, ratified by the people of Canada, written for and by the people of Canada. They chose not to do that. Instead, they chose to carry on as if nothing changed, when in fact, legally everything changed. Their government, provincial and federal, became de facto on December 11th, 1931. No longer legal or lawful. The Governor General, that position was created and appointed by the UK Parliament. The federal government was created by the Governor General on behalf of the UK Parliament. Canada had now become completely autonomous. We no longer had to follow any of their laws. We were free to create our own laws. But that opportunity was stolen from us. Why would they do that? Rather than become the true fathers of Confederation, rather than become the true fathers of the constitutions, provincially and federally, rather than become the saviors and true fathers of the birth of Canada, they chose to carry on the illusion that nothing changed. They've carried on that illusion for almost 90 years now. Every government has carried on the torch and perpetrated the illusion and the fraud and the omission against the people of Canada. Every government, provincial and federal, no matter the party, every government for almost 90 years. They all knew back then. They all know now they're part of the club. We're not part of the club. They want to maintain their control, power, and their money. That's all this is about. Some of you out there might not fully understand the Statute of Westminster and the ramifications to Canada and all the other dominions under the UK thumb at the time. Some of you might not agree with the absolute freedom and autonomy that I state that the Statute of Westminster afforded us. Well, let's have a look at what the Canadian government has to say about the Statute of Westminster. Why, in 1931, Canada chose not to exercise its full autonomy as provided for under the Statute of Westminster. So as you can see, this is a Government of Canada website. They fully acknowledge that Canada chose not to exercise its full autonomy as provided under the Statute of Westminster. Our absolute freedom. Why Canada chose not to exercise its newfound freedom. I would ask the question, why the Canadian government, on implied consent from the people of Canada, chose not to exercise its full autonomy as provided for under the Statute of Westminster. Other dominions did. Every other dominion did. Why not Canada? Why not give the people of Canada the opportunity to choose to stay with Great Britain or to create a Canada of our own? Why not give the people of Canada the opportunity to vote? Because the governments at the time didn't want to lose their power, control, and money. Period. For 90 years now, every government has perpetrated the illusion. The Statute of Westminster, 1931. The Dominion of Canada was constituted following the ratification of the British North America Act 1867 by the British Parliament. The British North America Act was never ratified by the people of Canada as a constitution. In 1931, the Statute of Westminster was ratified by the British Parliament. It granted the Dominions full legal autonomy, except in those areas where they chose not to take advantage of that autonomy. Some Dominions, including Canada, had in fact expressed reservations about obtaining their full legal autonomy. That's not true. The author of the clauses in the Statute of Westminster pertaining to Canada has, on many occasions, expressed exactly why he wrote the clauses the way he did, the full intent of the clauses, and the legal ramifications of the clauses. He wrote them with intent to give Canadians the opportunity to build the country we've always been taught and dreamed of. Period. He knew what to do after. He knew the next steps to be taken. Except in those areas where they chose not to take advantage of that autonomy, some dominions, including Canada, had in fact expressed reservations. The only reservations expressed were those of the provincial and federal members of the government who were fearing for losing their power, control, money, and jobs. The people of Canada never expressed any reservations because they were never properly informed and educated. They were never given the opportunity to vote. Is that democracy? Is that the rule of law, or is that the color of law? Canada's reservations relating to the Statute of Westminster. In the case of Canada, full legal autonomy implied that the British North America Act 1867 and the British Acts amending it, as well as the power to amend these acts, would become Canadian laws. It implied that they would become Canadian laws, or it implied that they could become Canadian laws, because Canada was no longer under any legal rule or obligation. We were free to choose whether to adopt the British North America Act 1867 and ratify it as a constitution by the people of Canada, or we could write our own constitution. Such a prospect was a source of concern for Canada, a federation in which jurisdictions are shared. Absolutely, it was a source of concern for Canadian politicians, not the people of Canada, because the people of Canada weren't properly informed and educated. So how could they have a concern regarding federation and jurisdictions if they weren't even properly informed or educated? Not only that, they were not given the opportunity to vote if they had any concerns. Who would henceforth have the power to amend Canada's constitutional acts? Only the government of Canada? The government of Canada and the provincial governments? This is absolutely ridiculous. This is absolutely ridiculous. Number one, Canada had the choice to either adopt and ratify the Constitution Act 1867 or create our own for every province, and then if we so choose, to create a federal one ratified by the people. In those constitutions, we could establish the power to amend constitutional acts. We could divide the power between provincial and federal governments. So this whole argument is Ridiculous, Canada's reservations relating to the Statute of Westminster. Well, the U.S. did it. The U.S. won their freedom from Great Britain, and the U.S. established their own constitutions on the state level first, and then on the national level. If they could do it, why couldn't Canadians do it? This is ridiculous. But this is the Canadian government's propaganda and excuse. Why they gave the freedom of Canadians back to the UK to personally hold on to their power, control, and money. In November 1927, Dominion Provincial Conference, there's been a whole bunch of conferences regarding the Bna Act, the Constitution, the problems therein. They're only listing one here. Canada's preoccupation relating to obtaining full autonomy remained. It was therefore proposed during the discussions that took place in London that the power to amend Canada's constitution be excluded from the provisions of the statute. Canada could thus acquire its autonomy at the same time as the other dominions and then settle the question in due course. Of course we could. We could have taken our freedom and said, we'll solve these problems later. We will establish an interim government to help us work through these problems until they're all solved, and we can carry on as sovereign nations or choose to unite into a federation. That could have been easily done. Easily done. The restrictive clause applied to Canada reads as follows. Nothing in this act shall be deemed to apply to the repeal, amendment, or alteration of the British North America Acts 1867 to 1930, or any order, rule, or regulation made thereunder. So basically the power to amend the British North America Act would remain that of the Parliament of the United Kingdom, which absolutely makes sense because it is an act, it is a statute of the Parliament of the United Kingdom. If Canada is autonomous, why would the UK Parliament grant Canada the power to amend an act of the UK Parliament when they're completely separated and autonomous? So down here on the end notes, since 1982, the British North America Act 1867 is known as the Constitution Act 1867. This was done through the Canada Act 1982 by Pierre Elliott Trudeau. Now, changing the name from the British North America Act to the Constitution Act does not make it a constitution. Not at all. It may create the illusion of a constitution, but it does not create a legal and lawful constitution. Let's have a look at some of the anomalies regarding the Bna. So this is the consolidated version of Constitutional Act 1867 to 1982. And down here we have the Constitution Act 1867. Once again, Pierre Trudeau changed the name from British North America Act to the Constitution Act. That did not legally change anything. That did not make it a constitution. All that did was give the people of Canada the illusion of a constitution. This is the Preamble from the Bna Act, now known as the Constitution Act 1867. This is the Preamble that arrived in Canada. This is not, however, the preamble that was read and passed and received royal assent by the UK Parliament and Queen Victoria. This is that preamble has been replaced with this preamble when the BNA was brought to Canada, when a copy of the BNA was brought to Canada. So any of you that are familiar in the interpretation of acts and statutes know that after the preamble comes another very important part of the statute. And in this copy, it goes straight from the preamble that was never discussed and never agreed upon in the UK Parliament, never received royal assent from Queen Victoria, this preamble, and it's missing a very important part. It goes straight into the preliminary and skips the enacting clause. The enacting clause is missing. Preamble, enacting clause, preliminary short title. There's no enacting clause. So the short title, this act may be cited as the Constitution Act 1867. Section 2 was repealed. Moving right along. The enacting clause was repealed by the Statute Law Revision Act 1893 by Queen Victoria. It read as follows: "Be it therefore enacted and declared by the Queen's most excellent Majesty and by and with the advice and consent of the Lords Spiritual, Temporal, and Commons in this present Parliament assembled, and by the authority of the same as follows. When you repeal a clause of a statute, that clause becomes dead in law. That clause becomes of no force or effect. That clause has no force of law. It was repealed. So when you repeal the enacting clause of a statute, that clause is no longer enacted. It has no force of law or force of effect. It's a dead document. The enacting clause of the British North America Act was repealed by the Statute Law Revision Act 1893 by Queen Victoria. Not only that, there was a number of other sections repealed. Moving along, Section 2 of the British North America Act, repealed by the Statute Law Revisions Act 1893, UK by Queen Victoria, read as follows: "The provisions of this Act referring to Her Majesty the Queen extend also to the heirs and successors of Her Majesty, kings and queens of the United Kingdom of Great Britain and Ireland." So Section 2 was repealed. That means that the provisions of this Act, the British North America Act, referring to Her Majesty the Queen, refer only to Queen Victoria. They no longer extend also to her heirs and successors. Only to Queen Victoria. Queen Victoria died in 1901. So the provisions of this act referring to Her Majesty the Queen also died in 1901, because Section 2, which extended also to the heirs and successors of Her Majesty, the provisions of this act. Let's look what that looks like within the Act itself. I'm going to jump down specifically to Section 9, which is executive power. So we know Section 2 is repealed, and any reference of the Queen in the British North America Act only refers to Queen Victoria and no longer applies to her heirs and successors. The executive government and authority of and over Canada is hereby declared to continue and be vested in the Queen. Queen Victoria and only Queen Victoria. She repealed Section 2 herself. Queen Victoria repealed the Enacting Clause of the British North America Act through royal assent of the Statute Law Revision Act of 1893. These are just some of the anomalies in the Bna Act. Moving right along, we're going to jump right into Canada, a country without a constitution. So let's continue.